Welcome, everyone. We're here today to talk about what happens if you are mortal. I'm Kim Browning, estate planning attorney with Blue Chip Estate Planning. And thank you for tuning in to our 12-part webinar series, The Dirty Dozen, about the most common estate planning errors. As an estate planning attorney and a probate litigator, I have over 13 years of experience in helping individuals and families protect their legacy, to minimize conflict, and ensure that their loved ones are taken care of when they're no longer around. So let's get started. Most people don't plan to fail, they just fail to plan. Now, I'll admit that as an estate planning attorney, this isn't your typical cocktail party topic. Most people don't wake up saying, you know what sounds fun? Let's talk about death. But here's the thing. We plan for everything else in life, careers, kids, retirement, even vacations. Yet we ignore the one thing that is absolutely certain for every single one of us, our mortality. This webinar is designed to help you understand not just what an estate plan is, but what actually happens if you don't have one at all. So if you've been avoiding this, you're not alone. But at the end of this session, you'll walk away empowered, not overwhelmed. Today's agenda. We're going to talk about what is an estate plan. What happens if you don't have one? Real world horror stories, and estate planning myths. And then we'll follow up with your action steps. So what is an estate plan? A complete estate plan gives your loved ones a roadmap instead of a legal puzzle. So let's clear up a big misconception. Estate planning isn't only who gets your stuff when you die. It's about who makes decisions for you while you're alive, and who gets what when you're gone, and how to avoid chaos for your family. So a typical estate plan will include a will. A last will and testament outlines who gets what and who's in charge, but a will only directs assets that are not jointly held, are not in trust, and do not have beneficiary designations. A will is a letter written to the judge because it only has effect through the probate court. A trust. Not all people have a trust, but it is a powerful document. It avoids probate and it provides privacy. There's a misconception that you have to have a large estate before you have to have a trust, but there are many reasons why a trust might be beneficial for you. Powers of attorney. We have a general durable power of attorney that appoints someone to handle your finances and legal matters if you're incapacitated. And in Michigan, we also have a healthcare directive. This, you appoint a patient advocate. This is someone who's able to make medical decisions in the event that you're not able to speak for yourself. It also can deal with end-of-life decisions. And then we normally do a separate HIPAA release. A HIPAA release is authorizing someone to have access to your medical records. Also, a very, very important part of your estate plan is a designation for guardianship for minor children. Who would you want to be able to make all care decisions for your children if you're not around? So think of your estate plan as a life insurance policy for your legacy. It protects your loved ones from financial hardship and from emotional turmoil. What happens if you don't have one? Well, dying intestate, that's what happens. Estate planning isn't about how much you have, it's about who you love. It's a plan for the ones that you care for. Dying intestate means that you don't have a will when you pass away, and the state has a will for you. It may not be what you decide. So it depends on who is in your family at the time, whether you're married, whether you have children, if you're single, if you have surviving parents. But the state will step in and make those decisions on your behalf. Not just who gets what, but who's also in charge. And those decisions quite frequently aren't going to be the people who you would want. Also, assets are frozen until court approval. The court has to appoint an administrator. The administrator is someone who won't have the ability to touch your assets until they receive legal authority. The judge chooses who inherits. So if you have a second spouse, but you have children from a first marriage, if you don't have anything in place and you want to leave everything to your children, the intestate rules through the use of the judge will interpret the law and make sure that that second spouse does get the marital election share. So your children might not get the full inheritance that you intend for them to receive. And the guardianships are decided by courts as well. Oftentimes, families, in already emotional time are struggling, and then to have to go through court, it's very emotional, especially for the children. Probate is a public court process. The documents that you file are available for anyone's review. So let's talk about probate, the default legal path, and that your estate will take without a proper plan. The time involved. Probate can take anywhere from 6 to 24 months, sometimes longer. It is expensive. It costs an attorney's fees, court fees. You have to get appraisals of assets. Maybe the court's going to set bond for your personal representative. So often 5 to 10% of the estate's value will be lost strictly in administrative fees. Again, it's public. When you go to the probate court, everything that you file is available for anyone to be able to access. One of the things that the personal representative must file is an inventory. The inventory lists item by item of the assets that are being distributed according to your will, and it gives a value. So it'll list all your real estate, it'll list your bank accounts, it'll list everything that goes through probate. And most people want their finances kept private even after death. Then we have family stress and legal delays. Your loved ones must gather the paperwork. Sometimes this is a scavenger hunt. Let's avoid the scavenger hunt. They have to navigate legal hurdles, trying to figure out how to get the process started, how to get your assets unfrozen. Your bank accounts are frozen. How do they access that? What do they do with your car, your vehicle? They can't drive a vehicle that belongs to someone who's passed away. So while you're still alive, it's important for you to do the proper planning. And while you're still alive, what happens if you have a situation? What happens if you have a medical situation, if you don't die? So if you have a serious accident, you're facing a medical crisis, and you don't pass away. If you don't have a power of attorney, then you have to have a guardian, a legal guardian appointed, or a patient a conservator appointed. Without a power of attorney or medical directive, your loved ones aren't going to be able to pay your bills, manage your affairs. No one's going to be able to speak to the hospital on your behalf. Doctors might not be able to administer treatments, or maybe they're going to administer treatments that you don't want. So the appointment of a guardian or a conservator is, again, back into the public purview because you're in the probate court, and a conservator is going to be appointed, or a legal guardian. You're going to have loss of autonomy. The people who you want to be in charge may not be the people that the court appoints. So having a plan in place ensures that you remain in control, even if you can't speak for yourself. Here's a case study of someone very famous who didn't have an estate plan in place. And it's Prince. Of my generation, Prince was one of, I was a huge fan, but Prince had no will, and now there's no peace for him. He was worth over $300 million. He died with no will, no trust, no plan, and his estate spent millions on attorney's fees. In addition to spending millions on attorney's fees, it was just years in court because there were many people who came forward claiming to be an heir. So it had to, I mean, it was a very long process to determine truly who his heirs were. And it was public, it was costly. His music catalog was controlled by the courts for years. So it was a very unfortunate situation for everyone. So if someone with Prince's resources didn't plan, imagine how easy it is for us to make the same mistake. Another case is a case that is very sad. I handled that involved 3 siblings whose mother died without a will. She had a modest home, no trust and no written instructions. And with the 3 siblings, there was one of the children who lived in the house. The other 2 were independent, and it was a long battle amongst the kids because it was, how are they going to deal with the one child who wanted the family home, and the other children were disputing whether or not they were going to evict their sibling from the home. And then it dealt with the expenses that were involved. Were the expenses of keeping and maintaining the home going to be reduce that one child share? So the relationships were ultimately destroyed. The kids stopped talking, and who got the furniture, how to sell it, all those legal battles can be avoided if you just plan a little bit ahead. This is a case study of minor children in limbo. So if you have no guardianship in place, no designation, the state chooses who's going to be guardian of your kids. So imagine passing away suddenly with minor children and no guardian is named. The kids in a case that I recently worked on were temporarily placed in foster care because 2 sets of relatives fought in court over custody. It took 9 months before a final decision was made. This is not a situation you want your kids to be in, and it can be avoided completely by some simple planning. myths that can cost you. As I stated in the beginning of this webinar, sometimes people delay because they think their estate isn't large enough. Oftentimes people think that they're too young. So too young, I don't have enough money. But quite frankly, if you have a car, you have enough money. Your family's gonna handle it. Well, maybe, or maybe they're gonna fight. They're gonna spend the money in court and then grow resentful. Coming to see an attorney and paying a fee to put your estate plan in place, it is expensive. It is something that people put off because there's always something else to pay for. Your car broke down, you've got to get a home repair, you have a medical expense. But the cost of doing nothing is far greater. So, and it's far greater not just in your bank account, but also in time and the relationships of your family. So you can't justify it by saying that it's just too expensive. What can you do now? Well, we can talk about how to get started. You should inventory your assets, which means make a list. Identify the real estate that you own, any bank accounts, any investment accounts, insurance policies, and the valuables that you have. Then you have to decide your decision makers, your captains. Decide who you trust. These are the executors, the guardians, and the healthcare agents. These individuals will have different responsibilities, so the personalities of the people that you choose are going to come into play with who you decide. For the guardians of your children, you may decide to choose someone who's along your same age, whereas the executor of your estate, your trust, you might decide to choose your parents or a sibling, or someone who is going to make sure that they take the responsibility seriously and they have the follow through. They have the personality where they're going to make sure things get done. And then your healthcare power of attorney, your patient advocate. How is someone going to emotionally be able to handle making medical decisions under pressure and dealing with end of life decisions? So those are the things that you're going to think about when you're choosing your decision makers. You're going to talk to your family about this, especially if you're going to nominate any of them to be in these important roles. If you're going to nominate someone to be the guardian of your children, you need to have that conversation with them to make sure that this is a responsibility that they're willing and able to take on. The same goes for the other roles of executor, being the trustee of your trust, or the patient advocate, and the attorney in fact under the durable power of attorney. You should also talk to your family to let them know that you've put a plan in place, where they can find it. We don't often recommend that you give out copies of your estate plan because your estate plan is something that changes over time and you don't want multiple copies out there, but they should at least know who your estate planning attorney is and where they can find the important documents. Okay. Oops, I'm going backwards. So the last thing is what you can do. You can meet with your estate planning attorney. We here at Blue Chip Estate Planning, we offer free consultations. Every estate plan is different. It's tailored to you. It addresses your particular family situation, the dynamics in your life, your assets, and we tailor it to you. So you can go ahead and give us a call. We're going to take questions now. If anyone has any questions, go ahead and put them into the chat. So there's a question, what happens if I put beneficiary designations on everything? Do I still need an estate plan? Well, again, beneficiary designations are good. You definitely want to have beneficiary designations. It depends on who those beneficiaries are, and if you have a contingent beneficiary, but it doesn't help you if you don't pass away. I mean, if you have a medical emergency or something that comes up, you still need someone who can stand in your shoes to make medical decisions. So you need a healthcare power of attorney. You also need a general durable power of attorney. And then what happens if those beneficiaries happen to be with you when this, accident happens? Are there contingent beneficiaries? So yes, it's important. That's a starting point to have beneficiary designations completed properly, but you still want to make sure that you cover all the bases of all the different aspects of your estate plan. Okay. Well, I don't see any other questions. I hope that everything was clear to everyone. As a good supplement to today's presentation, we would ask you to go ahead and feel free to download our free ebook. This is an ebook. It's called Estate Planning Demystified. It is authored by my partner, Robert Steinberg. It's a great resource. And to schedule your consultation, please visit us at www.bluechipestateplanning.com, or you can give us a call at 248-873-3244. Thank you very much for tuning in, and we look forward to seeing you again for part 4 of our series in 2 weeks. All right, thank you. Bye-bye.